Where there's a will, there's the potential for a nasty family fight. Now the Supreme Court has changed the law regarding joint assets that could create long, drawn-out and costly inheritance battles.
A wills and estate specialist clears up the legal mumbo-jumbo before you find yourself in the financial suit. Next on CH Live at 5:30. You can pick your friends, but you can't pick your family, and therein lies the problem. Something as simple as joint accounts can create family wars.
With little fanfare or attention, the Supreme Court last month changed the law regarding joint assets like bank accounts, homes, and investments. Now most assets held jointly by a parent and a child will not automatically go to the child when the parent dies. Instead, what happens to that joint asset on death will be determined by the parent's intention. And if the beneficiaries can't agree on what that intention was, the courts will have to decide who gets what.
Les Kotzer is an attorney whose entire practice is restricted to wills and estates. He joins us now from Toronto. And Les, why did the Supreme Court deem it necessary to change the law?
Well, a lot of parents are putting assets in joint names, so for example, a house or a bank account with one child to avoid probate. And they don't really want that child to get the asset. They want it to belong to all the children. But there are some parents out there that do indeed want their child to get the joint asset, the house. They may be the caregiving child. It may be a child from the first marriage, and they want that child to get the bank account or home, so they put it in joint names, not wanting the second spouse to benefit. But the Supreme Court basically changed the law because most people think if you own an asset jointly with a spouse, for example, it goes automatically to the spouse. But when you have an asset joint with a child, an adult child, now the law says it does not automatically go to that child when you die. The child must prove your intention. The onus is on that child to prove your intention after you have died. And it might be very difficult for him to prove what your real intention is when you're not there anymore.
Les, if you have power of attorney, can't you legally determine the intentions of parents who have passed away?
But that's not the asset. And the same thing, Lawrence, is with bank accounts. The court even said if you go into a bank and you sign bank documents stating that this is a joint account with the right of survivorship, that is not evidence of intention. So the parent must make their intention clear in dealing with what's called declaration of intention.
And okay, so let's say you have a cottage and you put the cottage in the name, while you're still alive, of all your offspring.
Yes.
Are you suggesting that once you die, that the offspring don't own the cottage?
Well, if you put it in the name of one child and you have three others, the others now own the cottage joint together. The child that you're joint with has the onus of proving that you indeed wanted him to have that cottage. So it's really the other children that can attack this. And as you mentioned, my whole law practice is about avoiding family fighting. I wrote a book called The Family Fight, Planning to Avoid It. I wrote another book called The Family War, Winning the Inheritance Battle. My whole law practice is about this. And when I heard about this case, I said, this is really important. It's the Supreme Court of Canada case which changes the law for any parents that have joint assets of any kind with one or more children, where all the kids aren't joint, where maybe one or two are and the others aren't. The others who aren't now can say, hey, John, you don't own that cottage when Dad died. It belonged to all of us in Dad's will.
And I suppose this happens more often than not when you've got perhaps an older man or woman whose spouse dies, they marry again, and of course then the kids have problems, the grown-up kids have problems with the new parent, the step-parent. And is that normally where these things occur? It can, and you know, for example, a parent may say, hey John, you know, you're my child from my first marriage, I really want you to have this investment account or this bank account, so I'm not going to put it in my will, I'm going to put you joint so that you'll own it when I die. I don't want my second wife, or in the wife's case, second husband, to get it. Now that changes. Now it's the onus on that child to prove that Dad wanted him, otherwise it could belong partially to that second spouse. Wow. And these legal fights will virtually destroy families, won't they?
Oh, destroy families, eat up the money. I mean, it's a nightmare. I see horror stories. I was on CNN last week talking about this, Lawrence. I'm seeing nightmares. Family fighting is just devastating, and my whole law practice is seeing it, and it breaks my heart, and I want to tell people how to avoid this problem.
Okay, how do you avoid this problem?
Well, I think it's important to deal with what's called a declaration of intention. You must specify your intention, and what my law firm has just done, Donna, is we, in reaction to that Supreme Court case, have developed what is known as a joint asset planning kit. This document was prepared by my partner, Barry Fish, who's an expert in the field, and what you'll do is you basically will deal with a document in the kit that either says, I want my son Lawrence to get the assets that I'm joint with him on, or I want all of my kids to benefit from the assets I'm joint on. So you'll have either way, either the one child who's joint, you can say I want him to get it, or the other ones. It is done legally, it's all done, you don't need a lawyer for it, we've prepared it, and as well, it follows the Supreme Court language, it does not revoke your will, and there's even a clause on the document which will not only protect your son from his siblings, but protect your son from his wife or your daughter from her husband, so that they can't attack the asset on divorce.
But can't you just do that in a will? Can't you sort of go to your lawyer and say, I want it? It's not
in your will. This is strictly dealing with a joint asset. Joint assets are not in your will because they're supposed to go automatically to the person you're joint with, so you rarely ever see a joint asset in your will. That's why we have to do a different document called the Declaration of Intention to avoid what's called the resulting trust on this document.
We better put up some information as to how people can get that. Give us the...
Sure. It's $45 plus the shipping, and they can go to either jointasset.com, that's jointasset.com, or they can call my office toll-free. It's 1-877-439-3999. That's 1-877-439-3999, and this will help to end any battles between your kids after you die.
Can I just ask you one thing? Sorry,
sure.
Donna, the one thing that bothers me, though, is that how come it's always we who have to end up paying for something that the Supreme Court does?
Well, it's either you pay me now or pay me later, because, you know, you're paying $45 now to avoid the problem, and your kids could be paying thousands and tens of thousands later to work this out after you've died. That's the problem.
I congratulate you for going ahead and presenting this kit. But, you know, can't an ordinary person just basically write something out and have it witnessed and they say that's good?
You have to be very careful. You can inadvertently revoke your will. I mean, this is following Supreme Court language, dealing with resulting trust. It's very complicated stuff. You know, if you want to go to a lawyer, by all means, go to a lawyer. A lot of lawyers don't even deal in this area. So we are experts in the field, and we develop something just to make it easy for people if they want to get access to it.
Can you do this retroactively, meaning if you are now with, if you have a joint account, a bank account with a child, and you're both still alive, can you now go back and say, wait a minute, I didn't realize the implications. What I really meant was I wanted all children, for example, to be part of it, so I'm going to change it, or can you do that now? I mean,
yeah, you can change. The only thing is, if you're joint with somebody, that you may need their consent to change it. See, this document basically says my intention is. So either your intention is it goes to John, who's joint with you, or the other intention is it doesn't go to John. It's meant for all of my children. So we have two different declarations in this kit that you will fill out.
A very important message. The website is familyfight.com. Our guest is Les Kotzer. Thank you for joining us.
My pleasure.
Thank you.